Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about professional secrecy of lawyers. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of complex litigation that took place over many years related to sexual assault claims in an institutional capacity, lawyers obtained a number of documents and engaged in internal communications that would otherwise be protected under the rules of professional secrecy. Those documents somehow came into the hands of opposing parties who attempted to use them to advance the lawsuit. The lawyers objected, claiming that the materials should be removed from the exhibits filed at trial and that those portions of the claims related to the things contained in those documents should be subject to the rules of professional secrecy. The court agreed, and the documents were removed. And the question that arose in the case was whether the length of time that had transpired, which had been several years from when the documents were received by the other party and used by the other party without the lawyers taking any action to claim professional secrecy, essentially amounted to estoppel, that it prevented them from then advancing a claim of professional secrecy given that the information was out and they did nothing to assert their secrecy rights over it. And this case raises very important issues about the doctrine of estoppel as it applies to the disclosure of privileged or secret information. At some point when something is so publicly known, it should give rise to the right to the public to use and have this information. The information in this case had been published in media reports, so it was at that point public knowledge, regardless of the assertion of professional secrecy, and still no steps had been taken to try and assert that power over it until the actual lawsuit was heard. And unfortunately, the Supreme Court of Canada really failed to consider the way in which the cat is out of the bag principle kind of has to apply in these contexts. At the end of the day, yes, privilege and professional secrecy are paramount considerations. But if a lawyer is so negligent as to not assert those things until the best strategic opportunity, it's hard to say that they really cared about the power of privilege and the power of professional secrecy that they did have. And the doctrine of estoppel governs in circumstances where people know that they can take actions and fail to act, essentially permitting it. It is almost as though the lawyers in this case effectively disclosed the information by taking no steps to conceal it. And the Supreme Court of Canada ought to have taken the opportunity to really address the way in which lawyers can't just lie in the weeds, and the way in which taking steps like this can complicate litigation by prolonging it and requiring claims to be amended and struck and having hearings that weren't necessary in the first place. Ultimately, the Supreme Court of Canada could have streamlined a little bit more some of the civil procedures that have been causing significant backlogs in civil courts across the country, and unfortunately, they chose the opportunity not to do so. Hopefully, another case comes to the Supreme Court of Canada where these elements of failing to act can be properly considered and rules can be put in place for the use to which information that has already been made publicly known can be used where claims of privilege or secrecy are asserted. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.